I'll reconvene and welcome Rachel, the rep for, or the submitter for Feds. Welcome, and we will hand over to you.
Thank you. Good afternoon. In this hearing, I note that there have been a number of pieces of evidence submitted in relation to this, and so we're standing by our request that sites are mapped, as we believe this is the intention of Section 6 of the RMA. But we do appreciate it's a very difficult position the council finds itself in, where a different approach is now being considered, and as a result, legal advice is being sought. However, as we mentioned in our submission, we think that conferencing with Hokonui Runanga would be beneficial for both federated farmers and Runanga and the council as well. Thank you.
Sorry, Rachel, I got distracted then. You were saying conferencing would be useful with the Runanga in relation to what?
In relation to understanding the position, and it's at the moment from discussions that I've had with Mr. Hegel, I believe that the approach may change, or that a variation is potentially going to be proposed through a way of introducing a new policy. And so federated farmers would just like to better understand what the approach is likely to be, and what it will mean in practice.
I'm sure the Runanga would be interested to have some dialogue with Feds.
That's something.
Oh, that's right. You're the... Yes, I'm sorry.
Today, mate.
Sorry.
No.
Yes. Okay. We'll have to give direction with that when we are able to, but that won't be today. Thank you.
Now, Rachel, there was some supplementary evidence presented to us this morning that I think responded to your question on fences. Was there anything else from Fed Farmers? Can you just take us through it again, please?
Yes, I can do in terms of the supplementary evidence. The definition of fences, we did amend it through the 42A report, and I did look at it again on the basis of the evidence received in terms of whether or not it needed to be further simplified. But the definition as recommended in the 42A report aligns with what is in the current operative district plan, apart from those exemptions that we've now removed. So the permanent division barrier screen is actually what is in the current plan, which I would have thought appears to be working okay. So I don't make any further recommendations to change that definition. In relation to the other evidence put forward by Federated Farmers, and therefore any supplementary changes I have made, they're in relation to the inclusion of the farm infrastructure definition, which I think we're in agreement of. We discussed briefly this morning about the potential for having some exemption for vet clinics in terms of their hours of operations. Also the removal of hours of operation for education facilities. I can support that. And I think that was everything in terms of changes that I made. So yeah, if there's any kind of outstanding issues that you wish to discuss, then we can.
Can I turn to paragraph 18, 19, which is in the evidence that's come from Rachel, and she refers to SNAs and that the government is looking at putting a 3-year delay on identifying further SNA areas, but at the same time we're required to protect areas of Indigenous vegetation. So I think it'd be useful for us to hear, and also for Fed farmers to hear, what's the difference between the two processes. And the plan actually flags that there'll be a variation prepared and notified in relation to vegetation areas, or is that with regard to SNA areas? So if we can just have an update, and then I'd like to hear from Mr. Garbutt in terms of likely timeframes for what the government's looking at.
Thank you, I can answer that. So the variation, I mean, this is obviously all in the Eco chapter, subject to a hearing next year, early next year. The variation principally relates to the mapping of SNAs and the rules associated with those SNAs. And what we had endeavoured to do was talk to key stakeholders about the mapping and the provisions that relate to SNA mapping, and then go and talk to affected landowners. So that was envisaged at the time the plan was drafted. Since then, we've seen the bill a couple of months ago, which is basically allowing councils to defer the mapping of SNAs, but that bill still notes that councils still have responsibilities to maintain Indigenous biodiversity pursuant to Section 31 and meet its functions under Section 6 in terms of Indigenous vegetation and fauna habitats.
So even with government saying defer SNAs, we've still got a responsibility to identify areas of significant Indigenous vegetation. Is that right?
We've still got responsibility to protect those areas. How you do that typically would be to identify them and have rules associated with that.
So does that mean that a variation is still required to identify those areas?
At the moment, the plan has rules about protecting Indigenous vegetation inside and outside significant natural areas. So the plan will need to change in order to deliver on whatever the bill enacts. We don't know that yet. We should know that by the end of this year. Whether we need a variation to implement that or not, we don't know at this stage, because we haven't seen the Act. It may be that we can implement the Act off the back of submissions, because there's a broad scope to submissions, right from throwing the whole chapter out to making controls tighter, etc. So I guess I'm saying it's hard to say at this stage because we haven't seen the Act.
And I guess that's not helping federated farmers, but, you know, we realise it's a concern. Do you have a question, Maria?
I have some just working through your brief of evidence. So do you have that in front of you?
Yes, I do.
Kia ora. So I was really interested in your paragraph 25 and the request for allowance for additional minor units, and that those minor units might not be for a primary production purpose. And I just thought I'd like to understand, you know, what those alternative purposes might look like. Did you have any examples in mind or anything to illustrate that request?
Yeah, absolutely. So, some situations where there's an au pair living on site, and the au pair might be to support the farming family, but is not specifically for primary production. Another family member on site as well. However, I do acknowledge that that it's not a requirement that it is to specifically support primary production as part of the rule.
And so you'd gone for, at paragraph 26, you were pointing towards the West Coast allowing up to 3 minor units attached to a single residential unit before consenting was triggered. And so I was wondering, understanding that there are certain drivers at play over there that are lending themselves to that, and I just wondered, was there anything magic around the idea of 3 and what the drivers might be for thinking about a number like that?
There's no magic around the number of 3. I think it's good to have some alignment with neighbouring areas, and 3 would enable this, you know, for an au pair, for instance, for perhaps another family member, and succession.
That's helpful to think about the sort of extended family approach, which is, I think, that's coming through. So it's more familial relationships and family function that you're imagining. And the reason that I was suggesting or wanting to understand what the drivers were is that I know the drivers on the coast are very much the tensions around worker accommodation, tourism impact, visitor accommodation availability, that kind of thing. So quite different sort of things going on there. But it's good to understand that in this district, what you're addressing really are those familial relationships.
Well, and that's S1, isn't it? So GRUZ S1 density that talks about no more than 1 residential unit per 40 hectares. Now, and then for sites under 40 hectares, no more than 1 residential unit per site. And the definition of site, that's where we've got a little bit of an issue, isn't it?
Not necessarily in relation to that rule.
Okay, so it does talk about a maximum density of 1 minor residential unit per site. So if a farm's got more than 1 title, are they entitled to more than 1 minor residential unit?
Yes. If they've got more than 1 site, by the definition of site, i.e. it's held within a different record of title, then applying these rules would mean that they could have an additional unit.
Which in part helps where federated farmers are coming from.
I would have thought so, yes. And then
And so if they apply for a restricted discretionary activity, it says there, number 4, minimum density of 8 hectares per residential unit or minimum density of 8 hectares per minor unit. I'm a little bit worried about what the word "or" means. I think the intent is that for every 8 hectares, you're allowed 1 residential unit and up to 1 minor unit per 8 hectares. So I'm just wondering whether the rule needs to be rewritten to actually reflect that.
Yes, potentially there is some room there. I think this is sort of previously and potentially traditionally, minor units are often attached to the number is attached to the number of residential
Yeah.
units, and
Yeah.
I guess because in a rural setting we've considered that actually there might be a need for multiple minor units depending on whether it's a familial type relationship or worker accommodation. That's part of the reason that we have approached it in a slightly different way than we have, say, the residential areas where we tie the minor unit to the, or we align it so that it's 1 minor unit per residential unit. The way that the rules are written is to enable sort of multiple minor units that support either the dwelling or the farming operation. So yes, I think you are correct that we might need to relook at that in terms of making sure we don't end up in a situation that we didn't intend to in terms of the restrictions of that rule.
Yeah, I think the point I'm also trying to raise for federated farmers is that the way that those rules are written, someone with a little bit of thinking through the wording and the way the titles are held on the farm actually is able to have quite a few dwellings.
I guess that's possible, yes. But if they've got multiple titles in a larger farm, then
Yes.
it's all relative, in my opinion.
That's actually not a bad segue to something we discussed this morning around the new farm quarry definition, which no longer refers to site because that was seen as limiting to a single land parcel, and that point was picked up by the Section 42A and the term farming operation was dropped in there. So our discussion this morning was, how do we understand what a farming operation is? And from the panel, queries were raised around what it is that we're controlling in terms of, I don't know, vehicle movements, if the farming operation's over disparate, unconnected titles. So I think there was some thinking going on around contiguous or continuous or something like that to help us understand what farming operation might involve. So that we're clear.
So is that a question to Rachel?
Can you illuminate how we might think about farming operation in relation to farm quarries?
Farming operation is very difficult, as I'm sure you all know. Many farmers own more than one farm, many of which are not contiguous. So yes, I think you thinking about what exactly it is you're trying to control. So potentially with farm quarries, it would be appropriate to think of farming operation as contiguous boundaries within a certain area, as opposed to as spread out across the district.
Yeah, and I take your point that it might not be appropriate to use that term for another purpose. We'd have to be clear. Yep.
Excuse me, were you suggesting another label for farm quarry could be explored? Maria?
Sorry, no, the
No.
Section 42A officer has adopted the term farming
Yes.
operation in the farm quarry, but we don't have a way of understanding what that is. So that's what I was just exploring, if we were going to define farming operations so we can be clear, how would we do that? Yeah.
I think it would be very useful to include a definition of farming operation within the plan.
At your paragraph 39 is where you're talking about building heights, and I wondered if, because you were suggesting, you know, up to the 15 metre, in contrast to the 12 metres proposed in that standard 8. And I wondered, has Fed Farmers done a comparison with other district plans in terms of height restrictions in the general rural zone to guide that? You know, for us at the moment, it's a choice between 12 metres and 15 metres, with a kind of a need to understand where each one is coming from to be able to make a decision.
Yeah, I understand. What we were really aiming for was consistency across the rural lifestyle zone and the rural zone, and we found it difficult to understand why 15 metres would be permitted in the lifestyle zone but not in the rural zone. However, as I think I mentioned in the evidence, it's really the exception that would be 15 metres. So there's plenty of tractor sheds which are 15 metres, but they're not that common. So we'd like to see consistency. So if it's going to be 12 metres, then perhaps it should be 12 metres in the rural lifestyle zone as well.
Yep, thank you.
For your info this morning, Rachel, we talked about vets and the hours of operation, and the 42A reporter acknowledged in the case of vets that emergencies do occur overnight, and it's probably appropriate to make provision for that. There was also the issue, I think, raised about education facilities in rural areas and the hours. And I think the outcome of that and the recommendation was that the hours come out, but the number maximum of 12 as a permitted activity stay, with restricted discretionary if it was more than 12. Are you comfortable with all those?
Yes, yeah, that's acceptable for us. Thank you.
So I think most of the last portion of your evidence is responding to the SESM approach. And obviously you're right, there was a lot of evidence that was brought forward on the beginning the conversation, basically in the hearing process, because it appears in the Mana Whenua chapter as a reference, which drew submissions and then created the conversation yesterday. And I guess when you're suggesting conferencing, there was some discussion yesterday around what might be conferenced and what that would focus on and things like that. I think what came out of that at the moment is we've got to do some thinking as a panel as to what's useful to do now and what's useful to wait until we can fully explore the whole thing, and then maybe narrow down what needs to be conferenced, because I think that would be a bit of a challenge at this end of this beginning phase, where we, in order for us to give directions on conferencing and things like that, it might be a little bit challenging if we haven't teased out exactly what needs to be conferenced. Yeah.
Yeah, I appreciate it's a very difficult situation, and I guess I just want to reiterate that we're not necessarily opposed to this approach, but we'd really like to understand in detail how it would work. And our goal is that farming operations can continue as normal without unnecessarily requiring resource consent or assessment against cultural values that can be time-consuming and expensive for farmers.
So on that, there's probably a difference between panel-directed conferencing and voluntary conferencing that occurs between submitted groups. So that's an observation. I can see lights on at the end of the panel, so I'll stop talking.
That was a good technique, wasn't it? So
turn mine on. I was going to ask a question, but I just wanted to make the point and invite your comment. We're trying to get definitive rules around rural activity as it relates to commercial agriculture as practiced in the Gore zone and rural zone, and we've accepted that that's a predominant activity and that it's very common. I'll invite a comment from you. I would suggest that agriculture as it's practiced is extremely dynamic and as such extremely variable. And I wouldn't like... Would you be concerned that the plan becomes too prescriptive in that it may, it may actually end up having people practicing agriculture in the conventional sense being caught up in a consenting activity that may not be necessary. I'll give you an example. Go back to height, and we're discussing what is permitted. Look, I might have a tractor shed or something that's quite low. Neighbour might have a grain silo and grain auger complex that's well and truly over 15 metres. And that's not a consent, you don't have to get a consent to put in a grain silo, but somewhere along the line, do you?
Yes, and quite regularly over the last 10 years or more, those grain producers or the dryers have got a consent on a piecemeal basis each time they want to put in a new silo above the height.
Well, that's interesting. Well, I suggest we should accommodate that, because they are quite huge.
Yeah, and they are accommodated to the extent that you need a consent because of their height and the impacts that they can have.
Okay, what is the process involved? Is it a...
So if you breach height, so your primary production, your activity rule, so primary production activities under GRUZ R1 are permitted, and part of that permitted activity status is meeting the standards, and your standards, obviously one of them is height. If you breach the height plane, then you need a restricted discretionary activity consent, and the council's discretion, which is matters that they can look at and ask for assessment on, is restricted to the matters listed in the plan, which we would have talked about this more in previous hearing streams, but our intention is to include restricted discretionary activities for breaching standards where possible in order to really direct decision making and make resource consent applications as pain-free as possible in terms of what the council is looking at and what needs to be assessed, and also then you move up to the objects and policies in terms of the outcomes that we're trying to achieve. So on the basis of this 12-metre height, as the Federated Farmers evidence said, beyond that is often the exception, and we can't, it's very difficult to write rules for every possible scenario, so we do have to land somewhere. In this case, we've landed at 12 metres.
Thank you.
Just wanted to check the rural lifestyle zone. So is the rule for height in that greater than the rural zone?
If I can jump in there, I think the reference is to the rural industry precinct.
Ah, okay.
So that is a higher height limit of 15 metres, and that's based on the anticipated activities in that rural precinct area, which could be your large grain drying operations or meat processing plants, which may have sort of larger buildings. So that's the reason that it is different.
Yeah, so I'm wondering whether Rachel had picked up on that. So where in fact you've got a rural industrial zone, which is a special precinct within the rural zone, you're allowed a higher height, and theoretically that zone could apply to the grain processors. So it would build it in there, Cliff. But I guess for Rachel, it may not be the inconsistency the way that you projected it to us.
Yes, that's correct. And to be honest, this, whether it's 12 metres or 15 metres, it's not of huge concern to us. You know, as I mentioned, it's very unlikely that these tractor sheds will be 15 metres. But what I will say, in picking up on some of your earlier comments, agriculture is incredibly dynamic. It is changing all the time. Things are getting bigger and bigger, and this is a plan that is supposed to last a very long time. So I just urge you to consider that when making these rules, which potentially could limit agricultural activities and make things harder for farmers, which I don't believe is the intention.
So while there's a pause in the remainder of the panel, I thought I will pick up where in your evidence around paragraph 50 you're pointing towards some of what was sitting in Dr. Murchison's evidence. And one thing that isn't discussed here, but because I thought you'd pointed to Dr. Murchison, I thought it would be a good anchor. In her evidence, she's got some clear signals around this plan that we have to make a decision on now might be thought of as interim, awaiting some further actions. And one reason, so whether it's mapping as proposed by Federated Farmers as an option, or the option that Hokanui Renaga were outlining to us yesterday, whichever one of those it is, the fruits of that effort, whether it's mapping or this district-wide cultural assessment, the fruits of that we don't have at the moment. So that point in Dr. Murchison's evidence is really salient for our decision. And so in some of the conversations that happened yesterday, if you go back and view that when you're back from holiday, don't do it now, enjoy your holiday. But, you know, when you go back and listen to those exchanges, some of what was happening there was teasing out what we are able to do in this interim setting, knowing that we don't have either of those things. We don't have mapping and we don't have the other cultural assessment that would feed into change. So based on that, we're left with things like the thresholds between permitted activity and then another path, which might be controlled or it might be restricted, discretionary. That's kind of what's in our wheelhouse at the moment, and also what those matters of discretion are. And so that was coming through, I think, in the exchanges yesterday around what we've got to work with at the moment. So that's one way of suggesting that having the fulsome discussion when we get to SESM, it's worth having that awareness as we go into that hearing, and think about each chapter as we go along and what those thresholds are and what the matters for control and discretion are doing. And I guess that's where we're going to be focusing some effort before we get to the SESM hearing.
That's really good to know, thank you. I think just picking up on that paragraph 50 and 51 in our evidence, one of our main concerns was that there's reference to high-risk activities in the plan, but then you have to actually go through and pick out what the high-risk activities are yourself, as opposed to that being contained in an appendix, or them being specifically identified. So
that was something that we discussed and tried to understand as well, and one thing that came through the evidence to us was that the assessment of what was high risk fed into the development of the plan. So that was something that fell out of some cultural assessments done that fed into the development of the plan, and then the settings, therefore the trigger thresholds in the different rules focused on certain activities. So that mention of high risk activities, which I also spotted and I think others spotted, this is actually what it's referring to. So it's more an acknowledgement of what went into the development of the plan and those trigger thresholds. That's what we've been informed by the Section 42A officer, who was nodding furiously to my right. So, that was an important exchange that happened yesterday that helped our understanding. And so I think perhaps, just viewing those exchanges as a good first step to think about, where to from here for the rest of the hearing and before we get to SASM.
Any more questions? Any more comments, Rachel?
No, that's all, thank you.
Thank you for making yourself available from distance. It's been worthwhile.
Thank you very much.
Thank you.
Right. Do we have more to come from Joe? Or have you completed your...
We haven't finished our questions.
yes, I know we haven't finished our deliberation part, but just before we go into that...
Oh, no, we've got lots of questions
Yes.
for Joe,
Yeah. We'll just have a break for a few minutes.
Okay. Page 46. That's on page 45, paragraph 188.
Just while we're pausing, Joe, can I ask you a question on GRUZ 1 on here? I thought when it came to primary production that we were recognising the importance, but you've added the words "and provide for."
Oh, yeah, well, if we do that with the recorder on, because I've got some questions on that too.
Oh, okay. All right.
And that there's three words that possibly mean the same thing.
Here.